Welcome everybody to these three wonderful papers. And my job is just to provide some comments towards the end, as well as to serve as a moderator. So if you have any questions, I think we can use whatever device that you want, but you could put your hands up or send me a private text message. So we will proceed in the order that we have on the program, and I'll just ask the speakers to just introduce themselves briefly at the very beginning before they talk. But it'd be Evan, Yuvraj, if I've got that right, and Jack. And everybody has 12 minutes, so I'll keep the cue and I'll let you know when you're close to time. So let's get going. We'll start with Evan.
Good afternoon, everyone. I'm Evan Bernick. I'm a visiting prof at Georgetown, and thank you all for coming here virtually to listen to my talk on my article, Anti-Subjugation and the Equal Protection of the Laws. The article attacks two doctrines that have been central to 14th Amendment law for about a century. The Supreme Court has held since the late 19th century that the 14th Amendment only applies to state action. So it doesn't apply when government officials fail to act to protect people against civil rights violations by non-state actors. This is the state action doctrine. And it's said since the late 20th century that the 14th Amendment doesn't guarantee any positive rights to government aid or resources. This is what I call the positive rights exclusion. The article argues that the state action doctrine and the positive rights exclusion violate the original public meaning of the Equal Protection Clause, and that the court's application of them prevents the clause from fulfilling its original publicly understood purpose. But fortunately, I argue that it wouldn't be too difficult for the Supreme Court to put things right, and I provide a roadmap that it can use to do so if it is so inclined. Here's the 4-point original meaning takeaway. Under the Equal Protection Clause, state governments are 1, required to impartially execute state laws that protect civil rights to life, liberty, and property. 2, required to provide people with impartial access to the courts. 3, prohibited from enacting discriminatory laws that affect life, liberty, and property rights. And 4th and finally, prohibited from denying to people any federal protection for life, liberty, and property rights that are provided by the law. So we have two kinds of positive rights to state resources: impartial law enforcement, impartial court access, and two kinds of negative rights to be left alone by the states: no discriminatory state laws touching life, liberty, or property, and no state interference with protective federal laws. Here's how I get there. I trace through Anglo-American history the idea that the government had a baseline duty to protect all people's natural rights to life, liberty, and property. Rather, there are civil rights that were in turn thought necessary to secure natural rights that people would be morally entitled to enjoy absent any government at all. So think bodily integrity, life, freedom of movement, liberty, and freedom to acquire and possess tangible and intangible goods, property. A duty to protect these baseline civil rights was widely accepted within anti-slavery circles from which the Republican Party emerged in the mid-19th century, and it became a fixture in Republican constitutional discourse. I then canvassed the framing and ratification of the 14th Amendment by the Republican-dominated 39th Congress and the post-ratification period, documenting the prevalence and sketching the contours of the duty to protect concept. And finally, I traced the emergence of a distinctive general anti-discrimination theory of the Equal Protection Clause that first became really popular among Republicans after the Supreme Court's 1873 decision in the slaughterhouse cases. This general anti-discrimination theory condemns all unreasonable governmental distinctions, regardless of whether those distinctions related to natural rights-related civil rights. Now, I argue that the general anti-discrimination theory, as normatively appealing as I find it, probably doesn't capture the prevailing public meaning of equal protection when the 14th Amendment was ratified. But there were compelling reasons for Republicans to invoke it, as they did later on in the 1870s. Republicans invoked equal protection to support civil rights legislation like the Civil Rights Act of 1875, which banned discrimination in public accommodations, because the most promising constitutional hook for a general anti-discrimination guarantee, the Privileges or Immunities Clause, had been rendered inoperative by the slaughterhouse cases. I mean, if you look at the congressional record, you can kind of see this happening in real time. The slaughterhouse cases took an extremely narrow view of the Privileges or Immunities Clause, and Republicans adjusted by shifting to equal protection. The second part of the article goes beyond original meaning to the original purpose of the Equal Protection Clause. Original meaning doesn't always give constitutional decision makers all they need, and it doesn't do so here. That's because the language of the clause is very general, and Republicans spoke in general terms about the kinds of things that it covered. So constitutional decision makers really need tools here that they can use to implement equal protection in unclear cases. Call these heuristics or constructions. I argue that those constructions should be designed to capture the predominant normative goal that the clause was publicly understood to be aimed at. I call this the clause's spirit or function. Of course, there's a multiplicity problem with identifying the predominant spirit or function of any law. In this case, we know that the clause is aimed at several things. Republicans wanted to protect formerly enslaved people from violence in the former rebel states. They wanted to guarantee to all people a concrete set of life, liberty, and property rights. They wanted to prevent the subjugation of some people's bodies and possessions to the will of others. And they wanted to end unreasonable discrimination full stop. So you have to ask the question of what goal most credibly explains the most about what Republicans were doing. The text itself tells us that the first of those goals, protecting formerly enslaved people only, is probably under-inclusive. The clause refers generally to people, and there's no contextual evidence that I discovered bearing upon original meaning that would suggest that most of the ratifying public would have read people to mean just formerly enslaved people. And the second goal, the concrete rights goal, fits better with the text, but doesn't fit the history particularly well. The phrase equal protection of the laws wasn't really a term of art with a narrowly defined meaning. And the last goal, ending all unreasonable discrimination, probably doesn't work because of consistent, widely publicized Republican assurances that the 14th Amendment wouldn't prohibit race-based voting restrictions. Those assurances shaped the original public meaning of the text. So if we construct the Equal Protection Clause to eliminate all unreasonable discrimination, regardless of whether it's connected to civil rights that are adjacent to natural rights, we'll probably end up overshooting the original meaning of the text by a considerable margin. So that leaves me with subjugation. And by subjugation, I mean the control of one's body and possessions by an external will over one lacks control. It's a family resemblance here to what the philosopher Philip Pettit calls non-domination. Being unknown to and unprotected by the law, and thus exposed to attacks on one's person, liberty, and property, both by state and non-state actors, was a major theme in abolitionist discourse around equal protection and in Republican discourse that was shaped by abolitionist discourse. And it doesn't require us to go way beyond original meaning. So when the meaning of the Equal Protection Clause is unclear, doesn't resolve the question, I argue that we should construct it so as to promote anti-subjugation. Now, none of this is currently the law. The court seems committed to the state action doctrine and the positive rights exclusion, and anti-subjugation isn't among its guiding principles. Is there any reason to think that the justices might be persuaded to change course? The court is clearly concerned that monitoring state inaction and requiring states or municipalities to provide a certain amount of resources would pose immense institutional difficulties for the judiciary. Now, I don't find these institutional arguments particularly persuasive. Other nations' constitutional courts have held government officials liable for negligent failure to protect people against violence by non-state actors. Those judicial systems have not collapsed or taken over municipal law enforcement functions. But I don't want to make the perfect the enemy of the good either. So I argue that if the court doesn't want to get involved, it ought to at least mark the constitutional territory and get out of the way. Congress can step in where states systematically fail to provide protection or themselves attack people's life, liberty, and property rights. And the text and design of the 14th Amendment suggests that the court should defer to Congress when it does that. Section 5 of the 14th Amendment empowers Congress to enforce the Equal Protection Clause through appropriate legislation. It's designed to make Congress the primary enforcer of civil rights for sound historical and institutional reasons. Historically, Republicans didn't trust the Supreme Court as far as they could throw the court's opinion in Dred Scott. And institutionally, Congress has fact-finding capabilities that courts lack, and Congress is better equipped to make generally applicable prospective rules. If you compare the rafts of civil rights legislation enacted by Congress in the 1870s to protect Blacks and their white allies against the KKK, and to dismantle Jim Crow in the 1960s, to the Supreme Court's uneven at best, terrible at worst record during the same time periods, that really becomes apparent. The court didn't work very hard to bring our equal protection doctrine closer to the original Equal Protection Clause. It does need to say that the Equal Protection Clause applies to state inaction. It does need to say that there's a positive right to protection. But it can then say it's Congress's constitutional duty to step in where states systematically fail to protect people or attack their life, liberty, and property rights. The only question for the court is the McCulloch v. Maryland question. Is Congress's means appropriately tailored to its ends? And the court should defer to factually supported, good faith congressional judgments in this area. The original meaning and spirit of the Equal Protection Clause could also be used to defend some of the court's most enduring criminal procedural decisions against charges of activism. I discussed Miranda v. Arizona and Gideon v. Wainwright, both of which can be defended as constructions of the Equal Protection Clause, because they're tailored to protect people against police violence and against wrongful conviction that deprives them of their liberty. That doesn't mean that they're constitutionally mandatory. Constructions can and should be discarded if they don't serve their intended purpose, but they can't be dismissed out of hand as lawless. Still further, the Equal Protection Clause could be used by members of ongoing social movements against police violence to seek transformative changes in law enforcement outside of the courts. These are in part movements for equal protection that rest on the premise that modern policing fails to deliver it. For all the compromises that it embodies, the 14th Amendment, in particular the abolitionist activism that gave rise to the constitutional theory on which it was based, provides constitutional resources that seekers of justice for marginalized people who often find that their voices can't be heard unless they sound in a constitutional register can make use of. I think whether constitutional discourse can contribute to any social movement's ends is a question that you have to answer on a case-by-case basis. But here I'm cautiously optimistic because the history of abolitionist constitutionalism is so rich and sadly so relevant. Now, it's true that on my account of the Equal Protection Clause, the clause does not forbid all arbitrary discrimination. It covers arbitrary discrimination with respect to civil rights to life, liberty, and property. So it covers things like discrimination in jury selection, filing fees that disproportionately burden the indigent, the pretrial detention of those who can't afford bail. But the farther you get from some connection to negative rights that would attach in the theoretical state of nature, the less likely it is that you can get to it through either the letter or the spirit of the Equal Protection Clause. I hasten to add, however, that the original meaning of the Privileges or Immunities Clause does guarantee to US citizens civic equality rights, like rights to vote and to be free from employment discrimination, and that I don't advocate displacing anti-discrimination law just because it's presently hooked on the wrong constitutional clause. Better that a guarantee that the original Constitution does make be hooked on the wrong clause than it be hooked on nothing at all. My concern here is to restore rights to protection that are baked into original meaning, but aren't presently enforced, rights that represent a constitutional promise unfulfilled. And I argue that the court could do a great deal to deliver on that promise without really doing very much. Thanks again for inviting me. I look forward to your questions.
Perfectly on time. Thank you. So we'll go through the speakers, do the comments, and then do audience questions. So I think Yuvraj, you're next.
Wonderful. I will try to share my screen. Can you see a presentation? Great. Wonderful. So I am Yuvraj Joshi. I'm a doctoral candidate at the Yale Law School. And I want to begin by thanking the conference organizers for bringing us together, and especially Professor Charles for engaging with our work. The paper I will present today is called Racial Justice and Peace. And it is one in a series of papers I'm writing about racial and transitional justice in the United States. The United States recently saw the largest racial justice protests in its history. People chanting "No justice, no peace" demanded a reckoning with the history, legacy, and future threat of white supremacy in this country. My article explores how these protests and these chants should lead us to reconsider American equality law. The article examines legal claims, which I call peace justice claims, that address the relationship between ameliorating inequality and achieving peace. Using unpublished archival documents, I tell the story of how Americans embroiled in early desegregation debates sought competing visions of peace that either included or excluded justice. and how the Supreme Court arbitrated those competing claims to promote integration despite massive resistance. The article also traces how those claims have evolved and how the court has used peace and justice considerations to limit rather than advance minority rights. By using sources of both legal and social history to capture the peace justice claims of not only lawyers and judges, but also policymakers, social activists, and lay people, the article contributes to what Risa Golubov calls a new civil rights history. Juxtaposing minority claims with court-developed legal doctrine highlights the Supreme Court's inadequate recognition of the peace justice interests at stake. This attention to peace justice claims is also enriched with insights from transitional justice, which is a field that helps societies to overcome histories of oppression. Although societies require both peace and justice, these values sometimes appear in tension, leading to what is internationally known as the peace versus justice dilemma. Viewing American legal cases as sites of this dilemma draws attention to how Americans define and prioritize peace and justice, and allows the experiences of other countries to inform the United States' struggles with racism. To make these contributions, the article proceeds in three parts. Part one describes how the peace versus justice dilemma discussed in international transitional justice theory sheds light on American racial equality debates. Transitional justice theory has a distinction between two kinds of peace: negative peace, which is the absence of violence, and positive peace, or the presence of justice, which are used throughout this article to analyze peace justice claims making in the United States. Part one then shows how racial justice advocates from the civil rights era to the present day have linked their visions of justice and peace. It studies previously uncited archival documents alongside public speeches and writings of three civil rights leaders, Dr. Martin Luther King Jr., Bayard Rustin, and A. Philip Randolph. To give you just one example of how these historical narratives shed light on today, consider this telegram that Bayard Rustin sent to New York City Mayor Robert Wagner in May 1965. Rustin described the previous summer's unrest following the police killing of James Powell as emerging from Wagner's failures to address police brutality and economic hardship. Rustin called for, quote, a bold social and economic program as a precondition for peace. He said, "For social peace cannot exist in a vacuum. It is a byproduct of justice obtained." He also warned that without such social and economic justice, unrest would continue. Wagner could either, quote, creatively meet the causes of discontent in the spring, or negatively face another long, hot summer. Pairing these historical records with national and local reporting of recent anti-racist protests shows that Black people continue making claims, peace justice claims, and points to the need for including their voices in legal discourse. And there are many ways to do so. We could recognize that there's a long history of Black political thought when deliberating contemporary questions of justice and peace. We could recognize that ignoring chants of no justice, no peace imperils the Constitution's mandate to, quote, establish justice and ensure domestic tranquility. We could also prioritize the claims of racial minorities and racial justice movements to reconsider the peace justice compromises struck by courts and other lawmakers. Building on this foundation, part two of the article examines Cooper versus Aaron, not as a case about judicial supremacy, but as a case about competing claims to racial justice and peace. Based on archival documents, including letters exchanged between politicians, organizers, and ordinary Americans, this part illuminates the peace justice claims made by integrationists and segregationists following Brown versus Board of Education and throughout the Little Rock crisis of 1957. Through a close reading of court filings and various opinions in the Cooper versus Aaron litigation, this part shows how the Supreme Court was invited to address an American version of the peace versus justice dilemma, which is resolved decisively, but in a limited manner. In 1958, a unanimous court held that Arkansas state officials who had refused to abide by Brown versus Board of Education must begin desegregating the state's public schools. Rejecting a school board's proposal to reverse and postpone desegregation in order to maintain public peace, the court concluded that, quote, law and order are not to be preserved by depriving Negro children of their constitutional rights. However, whereas civil rights leaders and many ordinary Americans saw integration as a means to a more just and enduring peace, Cooper adopted a more limited peace justice analysis. The court rejected white hostility as a legitimate basis for denying the constitutional rights of Black people, yet it stopped short of recognizing minority frustration as a basis for safeguarding those rights. Finally, part 3 of the article extends this analysis beyond Cooper versus Aaron to more recent racial inclusion cases in which claims to justice and peace have arisen. Cases like Parents Involved versus Seattle have clearly departed from Cooper, as a more conservative court now accepts resentments arising from racial inclusion as a basis for curtailing minority rights. This part goes on to consider limitations of this peace-justice balancing and what it would mean for the law to facilitate a more peaceful and just political order. While the Supreme Court has invoked white resentment as a reason to limit minority protective laws, it has ignored exclusion and estrangement of racial minorities as a reason to expand minority protective laws. More fundamentally, the Supreme Court has prioritized a negative peace based on the repression of social conflict over a positive peace grounded in the pursuit of social justice. A better equal protection law would attend to the actual causes and catalysts of social unrest, recognizing that some sources of unrest are more legitimate than others. It would also strive for the elimination of structural violence in order to truly mitigate social conflict in the long run. Once we recognize that these peace justice considerations arise across cases and bodies of law, we can begin to imagine a jurisprudence that does not hinge on the majoritarian peace justice claims or the preservation of an oppressive negative peace. In the most recent draft of the paper, which will be on SSRN shortly, I identify 4 areas of current legal controversy in which the Supreme Court could better recognize minority peace justice claims: affirmative action, voting rights, First Amendment, and Fourth Amendment. However, as the Roberts Court seems unlikely to deliver on racial justice, I also consider how racial justice advocates can steer American law towards positive peace by focusing their efforts on city council, state legislators and courts, Congress, and other democratic decision-making bodies. So, to quickly sum up, questions of justice and peace are entangled in conversations about social unrest. In the wake of the largest racial justice protests in the nation's history, and the rising tide of white supremacist violence, how will American leaders and judges respond? Will they finally begin ameliorating racial stratification in order to alleviate racial strife, or will they choose to face another long, hot summer? As the United States continues to struggle with systemic racism, institutions will face various versions of the peace versus justice dilemma, as well as competing peace justice claims. Recurring anti-racist protests should lead them toward prioritizing the peace justice concerns of racialized minorities and toward promoting a justice-based peace. I will end there and look forward to Professor Charles's comments on our conversation. Thank you.
Hard to believe that we are among a group of law professors. They are on time, succinct. I don't know what to do with myself. So now we'll go to Jack, who is practiced in not being on time and succinct, but maybe he'll show us that follow the lead of our earlier 2 people. So Jack Chen, take it away.
Thank you, Guy. I will fix the on-time and succinct problem that has existed in this panel so far. It's great to be here. My name is Jack Chen. I'm a professor at the University of California, Davis School of Law, but a former faculty member at the U of A. And it's great to be here and to see so many of you. And I really appreciate being on this panel because the papers are so interesting, and I find them in my own way so relevant to my work. So I'm interested in understanding more and writing about the depth and breadth of the history of white supremacy in this country. And my contribution in this paper is to talk about a case which I believe is unknown. In any event, it's unknown to me, and I haven't been able to find much writing about it, that was written by Chief Justice Taney 17 years before Dred Scott in 1840, but it deals with some of the same themes. It's interesting to me because in my mind, it helps explain the connection between Dred Scott, which in many significant ways was overruled in the course of the Civil War and the Reconstruction Amendments, and yet was revived in a significant way after the end of Reconstruction, reputationally and to some extent, I would say doctrinally. And this case, United States versus Dow, is also interesting to me because it's a race case, but it didn't involve an African-American. It involved a Malay person. And I propose that it anticipated a key feature of Dred Scott, and that is that in 1840, it articulated an understanding of the political history of the United States in which white people alone constituted the sovereignty in government. And that fact had legal significance. So Dow was a criminal case out of the District of Maryland. The government charged sailor Lorenzo Dow with murder based on a killing on a US flagship in the high seas of a white ship's captain named William Langdon. Chief Justice Taney explained at the time of the murder, the captain was the only white person on board. The crew consisted of the Malay, Lorenzo Dow, 3 Negroes and 1 mulatto. They were all free. Now, under the law at the time, US courts, US trial courts applied state rules of evidence. Chief Justice Taney understood Maryland law, where the trial was taking place, to provide Negroes and mulattoes, free or slave, are not competent witnesses in any case where a Christian white person is concerned, but they are competent witnesses against all other persons. And so this is 1840, and so there's no hint that maybe there's some sort of anti-discrimination rule of the kind that Evan talked about. It's perfectly permissible to draw race lines in evidence law. And so all of the witnesses against Dow were people of color. Dow himself, according to Justice Taney, the evidence showed, was a native of the town of Manila in one of the Philippine Islands. His parents were both Malays. They were Christians, and the prisoner was baptized and educated in the Christian religion and had always professed to be a Christian. Now, Dow claimed the benefit of the Maryland evidence rule. He said, none of these people can testify against me because they are Negro or mulatto, and I am a Christian white person. And therefore, the charges against me must be dismissed. There's no evidence, as they are in other cases where the only witnesses to a criminal event are incompetent to testify. And so Taney understood that with respect to this issue, the only question is whether he is to be understood as a Christian white person. And Taney said no, not a Christian white person, for 3 reasons. One is anticipating the scientific racism that we see in the cases from the US Supreme Court in the 1920s, like United States versus Thind and Ozawa versus United States. Taney says the Malays have never been ranked by any writer among the white races. The second point that Taney made was that Dow was not white because Maryland, when it was founded, could not have been a member of the political community. He said that only white Christians were granted political power and only they were entitled to immigrate. He wrote, the colonists were all of the white race and all professed the Christian religion. From the situation of the world at the time, no persons but white men professing the Christian religion could be expected to emigrate to Maryland. And if any person of a different color or professing a different religion had come into the colony, he would not at that time have been recognized as an equal by the colonists or deemed worthy of participating with them in the privileges of this community. The only nations of the world which were then regarded, or perhaps entitled to be regarded as civilized, were the white Christian nations of Europe, and certainly immigrants were not expected or desired from any other quarter. The third consideration was that some races were susceptible to enslavement by the white race, which made them dangerous. He said that the testimonial disqualification of certain races against white Christians was not that Indians or African people or African American people were inherently untrustworthy, poor reporters, had perceptual problems. No, it was the political situation between them and whites that required this testimonial disqualification. He says, Christian white men could not be reduced to slavery or held as slaves in the colony, but they might, according to the laws of the colony, lawfully hold in slavery Negroes or mulattoes or Indians. The white race did not admit individuals of either of the other races to political or social equality. They were regarded and treated as inferiors of whom it was lawful under certain circumstances to make slaves. These three races existing in the same territory, one possessing all the power and holding the other two in a state of subjection and degradation, it was natural that feelings should be created by such a state of things that it would make it dangerous for the white population to receive as witnesses against them themselves, the members of the two races which it had thus degraded. Peace, it's necessary for peace in the terms of the wonderful paper that we just heard. So Tawney had to explain how, he explained the situation of white people, he explained the situation of Indians, Negroes, and mulattoes. How does a Malay person fit into this? Well, Tawney, as you know, fancied himself to be quite a historian, and he found a freedom case, a freedom lawsuit from the Maryland courts, and it was initiated by a native of Madagascar. A person from Madagascar was held in slavery, claimed to be free, sued in the Maryland courts for liberty. And if you read the case, it's really, you can't tell what's going on because it's only one sentence. But Tawney went back and looked at the original papers. He's sitting in Maryland at the time. And what he came to conclude was that Malays might lawfully be held in slavery in the colony of Maryland, and consequently are not embraced by the description of white men as mentioned in the evidence statute, and the testimony offered is not excluded by that law. So the loss in this freedom suit in past decades affected Dow and the ability to testify against him now. Why? Well, Tawney's point wasn't that Dow was a slave from Madagascar, because he wasn't. He already said he's a free person from Manila. But because he was a member of an enslavable race, by definition, the law that precluded members of enslavable races from testifying against whites put him in the category of enslavable races and not white. So, thinking about how this relates to Dred Scott, obviously certain parts of Dred Scott were overruled. African Americans born in the United States are citizens, for example. But certain parts of it, I propose, remain good law. And one of them is the doctrine discussed in Dred Scott of Graham versus Strader, which Jamal Green has written about, and maybe and I use his work in the paper, that states have the right to determine the legal status of the people who reside in the state. And one of the legitimate classifications that they can use is who's a slave and who's not. And even though slavery, of course, is gone after 1866, that doesn't mean that there aren't a wide range of other non-slave statuses that can be imposed on people or not. So I'll close by saying that after Reconstruction, opponents of segregation made the argument that Dred Scott had not been overruled. They claimed to live under Dred Scott. And I don't think that this was completely hyperbolic or completely fanciful. There's an editorial from an African-American newspaper called The Appeal. And a part of it is the popular expression, "This is a white man's country," is an extension of Judge Taney's notorious dictum, "Negroes have no rights that white men are bound to respect." As thus amplified, the dictum includes the Chinaman and the Indian, as well as the Afro-American, and the Chinese exclusion bill is an instance of its practical application. The editorial was written after one of the Supreme Court's decisions upholding Chinese exclusion. So, you know, the idea that I'm sort of toying with is that that the part of Dred Scott that said that states can basically do what they want with respect to the legal status of people, descriptively remained good law after Reconstruction, and it was a multiracial, not African-American specific decision. Thanks.
Thank you. Thank you to all three of you. These were three great papers. They, in some respects, they speak to each other. I guess I should have introduced myself beforehand. I'm sorry. My name is Guy Charles. I teach at Duke Law School and happy to be here. They speak to one another, and I'm just going to work through them backwards. I'll start with Jack, and then Yuvraj, and then Evan. So Jack, I agree with you and two of the points that I understand you to make. The idea that the conceptual frame of Dred Scott applied much more broadly beyond sort of the black-white paradigm, right? So white supremacy, as we understand it, is not simply about Black subjugation, but narrowly defines what whiteness means. I also agree with the point that you made, which is that the state is differentially responsive to the needs of folks of color than it is to the needs of whites. So you point out early on that that whites are given certain rights like voting or property that were denied more or less broadly to non-whites. And so I take that, and I also take the specific point that the article addresses with respect to what is left after Dred Scott post the Reconstruction Amendments. Okay. But the question for me, though, is, all right, so what? What do we do with that? Right? What do we do with the descriptive claim? And that's what I wanted you to say more about. And there's a narrow part of the descriptive claim and a broad part, right? So you know, I don't want to admit this, but I think I've said this publicly, so I might as well continue to say it. I think Dred Scott is my favorite case. And it is my favorite case because I think it contains a truth, or really a series of truths, right, about who belongs in American society and about constitutionalism that haunts us still today. Right? So in some respects, you have to, when we think about the whole debate over the 1619 project, leave aside some of the arguments about the historical, some of the historical arguments, but the broader claim about how we understand the founding and the broader claim about who belongs, right? Dred Scott is the case that most honestly confronts those questions. But then it does leave us to say, well, what do we do with that? What does that mean? What are we take away from? What are we supposed to take away from it in the 21st century? And there's also a second question with respect to the interesting methodology here that you use, which is I want to use a prior and unknown case in order to shed light and illuminate both the jurist and author and also a broader and well-known case. And I was curious about that methodological move as well in terms of how generalizable it is. Okay, let me now say some words about Yuvraj piece. So also very interesting, as I understand the argument that that we haven't paid a sufficient attention to a peace justice framework that can help us understand much more broadly equality claims, and learning from a transitional justice method and pairing that with a civil rights and equality frame. So I think I have three questions for you. One is, what do you mean by peace? And how should that be domesticated for jurisprudential purposes? Two, and related, what do you mean by justice? So there's a way in which both statements are used for me in the article that makes it seem self-evident, or that makes them seem binary. And I wanted to understand more what we mean when we talk about the peace and justice claims of various communities, what it is in fact that we mean by that, because it seems to me that there could be more or less of either of those constructs, right? More or less peace or more or less justice. Okay. But my larger question, and I guess I have four, is twofold. The first is, you very nicely addressed, but I wanted to hear a bit more of how the court, and since this is more of a jurisprudential piece, should arbitrate among the peace and justice claims of various communities as they compete, right? So you want to privilege the peace and justice claims of, say, the Black community, but it wasn't clear to me exactly why, right? So take the context of affirmative action, in which the racial groups may have different preferences for a particular state of the world, right? And particularly if it's zero, if we live in a zero-sum resource constrained material frame, it's not clear to me why privilege the peace and justice claims of one group to that of the other. And of course, I think that's sort of that's one justification for constitutional law, is it's trying to resolve and think through different competing claims of different groups. And I wanted to hear a little bit more about that. One point though that I at least I may have missed, which is that part of what I think I find interesting and with American jurisprudence in this particular context is that it is often both law, broadly speaking, but the courts, narrowly understood, are often responsive to, particularly to communities of color, when they make non-peace claims, right? So we saw lots of action. Anti-discrimination law essentially found its footing in the mid-60s as a consequence of, yes, a peaceful, but also non-peaceful civil rights movement. Part of what is interesting in the current moment that we live in is also a set of responsiveness to a movement that threatens not to be so peaceful. So threats of justice but not peace, right, seem to be effective at least one way of thinking about that. So I wonder if you think that's true, if you don't think that it is, right? So if you think that you talk about King, and if you think that the civil rights frame of non-violent, is that the moral claim that then courts and maybe law is much more responsive to? But I'd like to hear a little bit more about that. Okay, Evan. Again, third, very interesting piece. I'm not an originalist. I found this piece very thoughtful. Your articulation and your frame, I found very attractive. But I also have 3, maybe 4 questions for you as well. The first question is, what is the work that originalism is doing in here in terms of helping us to think about the sets of questions you want us to think about in this project? So let me be a bit more precise. So towards the latter third, or maybe even the last 20% or so of the piece, when you talk about, say, the Black Lives Matter movement or the women's rights movement, and where you or more or less are addressing the objections, there's a concession that you make, right? You say something to the effect of, look, I am not arguing that the court gets rid of anti-discrimination law, or gets rid of the anti-discrimination approach, at least until it has supplanted it with something else. And that something else is in some respects a completely different vision. So given that that's not quite likely, what is it that you want this piece, this article to achieve? And here I have some possible suggestions that I want to throw out here. You do bring up the role of Congress and Congress's enforcement powers under Section 5. I wonder if instead of bringing that up, say, towards the latter part of the piece, if one way of conceptualizing this project is as a justification for congressional power when that power is exercised to achieve an originalist understanding of the purpose of the 14th Amendment, right? So that could have been one way of organizing and understanding the project, which comes in towards the very back end. But I wonder if there's another way of thinking it through by not placing more directly the power of Congress to think through to enforce the 14th Amendment under Section 5. The other way of thinking about this project is whether when not as a completely undoing of current equal protection or anti-discrimination doctrine, but as a supplement to it. So this is another way of reconceiving of the tiers approach, right? Which is to say, when the court is addressing an issue that is more or less at what you think of as subjugation, then it ought to apply strict scrutiny in that context. All right, so maybe more of a modification of the court's jurisprudential approach than a replacement of the court's jurisprudential approach. The last question then that I had for you were some of the things that you very nicely and directly addressed, but I was not very satisfied. So I was not sure how to think about gender. You promise and say, look, there are questions of anti-discrimination rights are best addressed through, say, the Privileges and Immunities Clause. And this goes to my first question to some respect. It's not clear to me what then is the theoretical approach that implies a formalism, a formalistic understanding of constitutional interpretation. P&I is meant to do this in that category, but equal protection is meant to do this, consistent with originalism. And I'm not sure exactly what the justification for the clause switching and that level of formalism. And I think I would have liked some, given the cost of your approach, which you're very upfront about, I would have liked some justification for the clause switching aspect of it. So let me just stop here and give you all a chance to say some words. We'll give you 5 minutes or so, and then we'll take the last 15 or 20, 5 minutes, that's so unfair. But for our audience, if there are any questions.
Great. So I guess I'll start. First of all, thank you for those comments. I'm sure that they will help the paper going forward. You've touched upon a number of things that I have come to realize that I really need to strengthen and clarify in my paper, particularly to those who are non-originalists and who don't share the frame that I'm bringing to the paper. The paper takes an originalist standpoint for a couple of reasons. The first is because I am an originalist for, broadly speaking, rule consequentialist reasons. And the second, because I believe that the Supreme Court, at least as it is currently composed, is responsive to originalist arguments. And to the extent that I want to ultimately serve the cause of racial justice, I want to be able to formulate arguments to which I believe the court will be responsive. So it's both. That
latter part is helpful. I don't mean for you to justify why you're an originalist.
Yeah.
That would be silly of me to ask, and I respect the approach. But but the latter part of, hey, here's how we can achieve, like that seemed to be slightly implied in the piece, but would have been nicely explicitly articulated. Sorry to interrupt.
So to draw an analogy, if not a comparison, I don't want to compare myself to Dorothy Roberts, but she's got this great article that's entitled Abolitionist Constitutionalism, where she brings to bear interpretive resources drawn from abolitionist constitutionalism to argue essentially for a number of prison abolitionist projects. And she draws upon the 8th Amendment, she draws upon the 13th Amendment, and she offers these resources in a spirit of solidarity, recognizing that what she's doing, insofar as she's relying upon a document that is limited and flawed in a number of ways, is going to amount to a non-reformist reform. It's not going to take us into a transformational state. It's going to reduce some harms and to build power such that we can achieve over a much longer term, something that's more consistent with what we would ultimately want. And that's pretty much what I'm trying to do, particularly in the latter half of my paper. Trying to navigate both between saying, look, I'm an originalist, I want to take original public meaning seriously, and to get at it while also saying I want to provide interpretive resources to something that I'm normatively sympathetic with is a tension that I'm trying to work through throughout the paper. And I think that reflects some of the limitations that it has now. One of the idea that I had along the lines of your suggestion with centering the role of Congress is thinking about the Breathe Act as constitutional construction and thinking about how my view of what Congress is empowered by Section 5 to do could do by way of providing support for sweeping civil rights legislation like that. So this was drafted before the Breathe Act was even on the table. I think that I need to acknowledge it and to engage with it. And that's something that I'm thinking about doing. With respect to the clause switching approach, this is also something that's tricky. I want to make clear that I don't want to take anything away from anti-discrimination law that I don't think can be underwritten by the Privileges or Immunities Clause, because I think it is so very unlikely that the Supreme Court will take up the Privileges or Immunities project. So my goal is really to like hold everything constant while adding a couple of things that the Supreme Court has under-enforced by way of equal protection. And my justification for that from an originalist point of view is, better half a loaf than none at all. And it would, in my view, be like a form of bad originalism to say, well, all of this really should be done under the Privileges or Immunities Clause. The Supreme Court hasn't shown any interest in reviving the Privileges or Immunities Clause, so let's protect none of these civil rights. I think that takes you way below the original baseline, even if some originalists may want to defend it. And separately, I find it extremely normatively unattractive, and I don't want any part of it. So that's my approach with respect to that.
Awesome. I'll jump in right here. Thank you so much, Professor Charles, for those questions. They are ones I've been grappling with.
Guy, please.
Guy, although you will always be Professor Charles to me. So just to quickly run through what I took away as the 4 key questions. And I think the first two can be combined, which is what do I mean by peace and what do I mean by justice? Part of what the paper is trying to do is show that there are actually multivalent ideas in play and that they are contingent. So peace in Cooper versus Aaron and the Little Rock crisis was framed as an immediate threat of violence. Whereas in more recent cases, whether they're desegregation or affirmative action, peace works in the register of harmony and understanding and ability to live together in the wake of racial conflict. And part of what is perhaps lacking, or if I'm lacking in conversations about anti-balkanization, for instance, is that they very much work in the reconciliatory register and don't acknowledge that there are actually multiple notions of peace that can be brought to bear on these conversations, and that peace need not only mean the presence of harmony or the absence of violence. It can actually mean the presence of justice in certain circumstances. So similarly with justice, part of what is appealing to me about transitional justice frameworks is that because it's comparative, transnational, and understandings emerge from many different contexts, it admits of different understandings of justice. Justice can mean accountability for crimes committed, massive human rights abuses within a transitional justice framework. It can also mean restructuring, fundamentally altering societal institutions that have enabled those crimes to be committed. And by taking these sort of more expansive understandings of peace and justice, more capacious and more contingent concepts, I hope that we can have sort of a cross-temporal, cross-doctrinal conversation in the US cases. So that's part of what the paper is trying to do, and perhaps I can communicate that intention more clearly upfront. In terms of how courts should arbitrate competing marginalities and competing claims, and much of my writing is about affirmative action. I don't want to confer legitimacy on Edward Blum's notion that somehow he's representing Asian Americans. And that's partly evident by the fact that even though he claims to be representing Asian Americans, the peace justice arguments are no different really in the Harvard case than in Fisher. We still get the stock notion that any racial classification is divisive. The justice claims perhaps can be differently interpreted. But even if it is the case that there are competing marginalities in play, and there might be other jurisdictions, the South African Constitutional Court has dealt with this question since the 1990s and has openly acknowledged that, various communities were oppressed under the apartheid regime, but that does not mean that they were oppressed in the same ways and that their oppression meant the same thing for the law and for society. So that's a conversation, forthright conversation we can have in the United States. But I don't think the Harvard litigation is really representative of any legitimate competing marginalities claim. At least I don't want to confer legitimacy upon it as such. Finally, your question about the non-peaceful, and that's really interesting. This is in the footnotes and perhaps it should be in the body. Philip Randolph openly invoked the threat of Black nationalism to make his position seem relatively more peaceful and thus more acceptable, right? When he was in conversations with white liberals, he was saying, well, you may not like our civil rights model, look at the alternative that's available to you. So certainly, I think the arguments across the spectrum are doing different work and interact in interesting ways, and that's also true today. So perhaps a point I will acknowledge more fully in the body as well. Thank you so much for those questions.
Well, Guy, I'm glad to hear that Dred Scott is your favorite case. I'm confident that it's not your favorite outcome, but I obviously agree with you that it's tremendously revealing. So one of the things that I guess I'm trying to accomplish in the paper, was completely concealed, and that is there's three documents that are particularly relevant to understanding Chief Justice Taney's view of history and view of the American political origins. He wrote an opinion as Attorney General that explained why African Americans couldn't be citizens. He wrote a long memo after Dred Scott that elaborated on some of his reasons, as if his opinion wasn't convoluted and prolix and repetitive enough. But I want to make the argument that this is a necessary document in understanding Chief Justice Taney's view historically. This should have been in Fehrenbacher's book about Dred Scott. The reason that I think is important is because I don't think that the concession or acknowledgement or position that you stated at the beginning, that Dred Scott is not exclusively about Black subjugation, is universally accepted. And I don't want to argue, not because I'm agnostic about it, because I don't believe it. I don't believe that that it's useful to create a hierarchy of discrimination, or that Asian Americans are worse off now than African Americans, or were worse off in 1900 or any other point. That's not my argument, but my argument is about the nature of white supremacy, which was not, I want to argue, a specific quarrel with, or a specific, desire for Indian land coupled with a specific economic labor system that some people were attached to, chattel slavery, that had to be dealt with in some way. There's a deeper and broader concept here of the United States as a white nation, and the whiteness, I think, is more important, significantly more important than the Christian part of it. And this is, as Deep might say, it's a data point, and it's one that's proved, it's proved at a later time through the Asian exclusion cases. My point about that. But what I want to say about that is that, that's not an afterthought. What happened from 18 whatever, into the 20th century, it wasn't, oh, now we have to start thinking about these other groups, Asian immigrant groups. We already know that those who had this attitude, that it's a white country, and so if we are to conclude that you're not white, then that means you are in this Graham versus Strader, Plessy versus Ferguson regulatory regime. And so what it has to do today is, is indirect, right? A lot of that's gone, but if we're thinking about sort of the cultural, social roots of white supremacy, I think it's helpful to understand its nature. That's the point, and it's a difficult one really to put on paper.
Perfect. Mark Graber has raised his hand. Please use either the hand function or send a message. Mark, you're up.
First, these were just terrific presentations. Thank you very much, everyone. Question about 90% of Jack, though I think Evan and Yarav may have some things. And it goes like this, that in one sense, one reason why Dred Scott may be Guy's favorite case is Dred Scott says that, well, African Americans can't be a citizen anywhere because citizenship comes with an extremely robust set of rights, which means once you declare African Americans citizens, they get those robust set of rights. And the horrible opinion is Curtis, because Curtis says, well, Dred Scott could be a citizen and have no rights because citizenship doesn't come with any rights. And it's interesting that, in fact, American law switches to Curtis once, in fact, African Americans become citizens. So I'm wondering whether, in fact, it's actually 20s Dred Scott doing a lot of the horrible work in the late 19th century, or Curtis's Dred Scott. And to some extent, what it goes to Evan is notice, in fact, there are two notions of citizenship sitting side by side. And again, once African Americans become citizens, we desperately want to read the Privileges and Immunities Clause. Yes, 20, that great, wonderful human being, and read Curtis, the Northern hero, out of the tradition.
And yeah, I mean, it's an important point. And I guess I would say, when we think about the ambition of the 13th Amendment, I think Curtis and Graham versus Strader work well together, in the sense that there was this idea that there were these two categories, slave and citizen, as I understand it. And once we no longer have enslaved persons, then they're citizens. And very quickly, the law innovated to say, well, maybe they're not citizens, and even if they are, maybe we can use the black codes to discriminate against them. And it seems like, the idea, first of all, I'm not sure that it's super clear that the citizen rights view trumped the Graham versus Strader view, because there were plenty of citizens who couldn't vote. And that was up to the state to decide, including white males who couldn't vote. And so, I think the one point that comes to mind in response to that is, that doctrine or principle is often sort of a thin protection for rights. And, it had this built-in flexibility, to accomplish the larger purpose through this sense that, you know, that the states could change the status of a person.
Yeah, I think that's a really good point. And one thing that's interesting that I've come across in my privileges or immunities research is that you do see some Republicans and abolitionists drawing upon Chief Justice Taney's opinion and saying, he's actually right about what happens when you're a citizen, and also free blacks are citizens, and also everybody who is born or naturalized in the United States should be a citizen. So therefore, it follows X, Y, and Z. But you know, both choices are, you know, extremely unattractive for their own reasons, right? On the one hand, you have a robust notion of citizenship, but the class of people that can enjoy that citizenship is very limited. On the other hand, you have a broad class of citizens. However, states effectively can do what they want with respect to filling in an empty vessel, or they can decide not to. And it is a tension that I think does run through the period through Reconstruction. And one case that that comes to mind in connection with this is Cruikshank, right? You have the Privileges or Immunities Clause read in a way that allows states to essentially do what they want, because the slaughterhouse cases have defined the privileges or immunities of US citizenship very narrowly. And Cruikshank says, well, the Bill of Rights really only applies to the federal government still, even after the 14th Amendment. So you have a very thin notion of citizenship that really doesn't give you very much, even if everybody's a citizen.
Philip, I think you have a question for Yuvraj. I can ask Philip's question. So the question is, what are your thoughts about monetary reparations as being an objective of modern racial justice? How may or may not this morally and constitutionally be justified?
So I would refer you on that to a booming reparations movement and efforts in California, in Evanston, Illinois. Their reparations are already happening or beginning to happen within the United States, and are precisely the sort of reckoning based claims that the law has not recognized, and particularly jurisprudential law has not recognized, for reasons of temporality, whether it's like a literal statute of limitations, or notions that it's just been so long since slavery and Jim Crow that there is no claim that can be made by descendants of slaves and other marginalized groups. I would see that within my framework as an attempt to steer the United States towards positive peace outside of jurisprudential models.
Other questions for we've got a couple minutes left. Questions or comments for our panelists?
If we do, I'm sorry to just jump in here and before raising my hand. My name is Shakira Sanders. If we could hear from our moderator about why Dred Scott is his favorite case, that would be quite interesting. I have to admit, I'm very distracted by the statement that you made earlier.
Well, as Jack said, it's obviously not the outcome, obviously, but it is as I mentioned, it's a case that says, and from my perspective, in many ways, some of the truth, right, which is the way in which, right, that the American constitutional framework was not intended. So, for example, when somebody like Nicole Hannah-Jones says the American constitutional framework was not intended to include Black people, then everybody gets upset with that statement. I think that's where there are few places in American jurisprudence where we can see the racism full in effect, where we could actually point to and say, here it is explicitly. because we have a tendency to deny it all. So it's hard, you can't look at Dred Scott and look away, right? You have to look at Dred Scott and you have to face up with its racism. So it's an easy place to point to in order to address the fundamental tensions in American constitutional law. It's not the only place, but it's an easy place. So I don't mean that Dred Scott is my favorite case in the sense that I love Dred Scott, just so that we are clear, right, in case it was unclear. Margeline Armstrong.
Marjolaine, thank you.
I'm sorry, Margeline, my bad.
Evan, I had a question about your paper. As you were talking, I just kept wondering where corporate citizenship fit into your analysis. Could you address that, please?
As a matter of the Privileges or Immunities Clause, corporate citizenship is not a thing, at least not in the course of the antebellum cases fleshing out the meaning of citizenship that we have reason to believe that the framers and ratifiers of this 1868 amendment would have been relying upon. So I think that corporate citizenship is pretty indefensible as a 14th Amendment matter, which means that to the extent that the 14th Amendment is being used as a hook for incorporation in cases like, well, in a lot of cases, in Citizens United and such, I don't think that you can get to those cases as a matter of original meaning. And I think it's frankly quite embarrassing that originalists have really only started to engage with this. Most of the people who have pointed this out have been non-originalists. And but Larry Solon has a recent paper about citizenship that gets close to this point.
Thank you.
Mm-hmm.
We are out of time. Like to thank our panelists for three wonderful papers and really thoughtful engagement. So thank you, and thank you all for coming.